Good morning, friends. Today we will discuss distinction between obiter dicta and ratio decidendi. Generally, as an advocate in a legal case, we are dependent upon the different judgments, judicial statements. If we are aware which statement is obiter dicta and which is ratio decidendi, then we are able to effectively represent our client and get winner in our case. So let us know what is the distinction between obiter dicta and ratio decidendi. Firstly, a judicial statement in a legal case consists of two different elements which we refer as ratio decidendi or ratio simply and obiter dicta or obiter. The ratio in Latin sense means reasons for the decision or judgment, while obiter usually refers to additional opinions or observations that are made on the issue. Obiter reveals the rationale adopted by court to come to conclusion and is not binding part of judgment. No doubt, ratio is the reason behind the decision, but it is actually more than that. Ironically, when a precedent has multiple reasons, all reasons are binding. To find ratio of judgment, one should look at the abstract principles of law that have been applied to the facts of that particular case. Obiter dicta. Obiter generally refers to remarks made by the judge which are not binding upon the parties. Statements which are not crucial but refer to hypothetical facts or issues of law not related to case sometimes also form a part of obiter dicta in a judgment. Unlike ratios, obiter is not the subject of judicial decision even if the statements made in this part are correct according to law. A decision of the higher courts like Honorable Supreme Court and the High Courts generally sets a precedent for the courts below. So they have to follow the precedents of the higher courts. Now coming to how to test whether a particular proposition of law is to be treated as the ratio decidendi of the case. The proposition is to be inverted, that is, to remove from the text of the judgment as if it did not exist. If the conclusion of the case would still have been the same even without examining the proposition, then it cannot be regarded as the ratio decidendi of the case. It is not the findings of material facts, direct and inferential, but the statements of the principles of law applicable to legal problems disclosed by facts, which is the vital element in the decision and operates as a precedent. Even the conclusion does not operate as a precedent, albeit operates as res judicata. Thus, it is not everything said by a judge when giving judgment that constitutes a precedent. The only thing in the judge's decision binding as a legal precedent is the principle upon which the case is decided, and for this reason, it is important to analyze a decision and isolate from it the obiter dicta applying these principles. So, this is all about the concept of obiter dicta and ratio decidendi. So, go through the judgment deeply, whether the statement, judicial statement is of binding nature, so that it may be quoted in the in our case to get relief. And no doubt obiter dicta is also a statement, but it has only a persuasive value, whereas the ratio is of binding nature for the junior course. That's all. Thank you for watching. Meet you again. God bless you all.